Today's Cardinal Lesson, we're going to teach you how to skip the probate court. You're actually skipped it anyhow because you're deceased, but in your estate planning, how we can keep your heirs out of the probate court. And we're going to do that by use of beneficiary designations, transfer on death. There's a POD, there's a number of ways where we're going to state right within the contract of your financial accounts and insurance policies who the money goes to. Completely bypasses the probate court. And then we're going to talk about how we deal with real estate. But before we go into that, I want Tom to share with you why we're doing this video today.
Yeah, we're doing this video because you might have done a great job saving and you spent your whole life doing this. If you don't get this part right, you're going to cause a huge headache for your beneficiaries, for your family, for your kids. And so we need to, it's not that hard to set up if you know what you're doing. So we just want to give you the tools of how to do it. But this is important. This is one of the more important things that we help clients review and get right. So let me bring up the show notes. You can find these below the link on our video. They're also on our website at cardinalguide.com. Today's show notes are pretty light. They're just a copy of the board. Some people print them out so they can take notes on them and do stuff like that. So again, no other further details on this one. So let me turn it back to Hans, and we're just going to go one by one, walk through the different types of accounts, how to pass them on to your designated beneficiaries who you want to receive the money, and how to do that properly. So Hans, why don't you start with the beneficiary designations?
Yeah, before I go over that, we're going to just talk a little bit about probate. What is it? Is that, you have a will or not. If you don't have a will, the state's got one written for you. But it's called dying intestate. And then the probate court will actually use the laws of the state as your will. But assuming you have a will, your executor needs to take the will to the probate court and prove the will. Essentially, is that the court is then going to instruct the executor to distribute all your money and your assets to the proper beneficiary. Okay, and it sounds great, but I can tell you that, first of all, it's a court process, and you know how court processes work. It takes a long time, and there's delays, and and it just goes on and on and on. It's a time delay, sometimes several years before a will gets probated and all the assets get distributed. Fees, it costs a lot of money. First to pay the attorney to go put it before the probate court, and then to pay the court itself. It's in the public record, so everybody that's nosy can read about your distribution of your assets after your death. And probate is public. It's in the court and it's in the public eye. And then creditors, if you owe any money to anybody or they think you owe them money, they can come at your estate for the money through the probate court. And that causes further delays, as even with probate, you have to run ads and attempt to reach and find any creditors or make it in the public record that so-and-so died. So that creates a delay. And then challenges is that somebody, a distant relative or a son by another marriage or daughter or somebody somehow couldn't like what it says in the will, and they can come challenge the thing from afar or up close. I mean, it's just, the probate process is a very necessary process where the state and the courts take your stuff after you pass away and distribute it to whoever it's supposed to go to according to the will. So I don't want to talk about it like it's bad, but if there's a way to bypass it, that's what we think you want to do. So now I'm going to talk about beneficiary designations. The way we bypass probate on any financial asset is we're going to name a beneficiary, or we're going to name a transfer on death, or we're going to name a pay on death on a financial account. So now, instead of passing by will or passing through probate, the money is going to transfer directly to the named beneficiary by operation of contract. I mean, that means the money goes straight to the named beneficiary. So we talk a little bit about beneficiary designations. every IRA and 401k has to have a beneficiary. And most of them, if you didn't name one, and I think they make you name one on the way in, it's going to be the estate. And you really don't want to do that, because if you name the estate, it's going to stick it's going to stick it right into the probate court. Okay, so you don't want to do that. Typically, so an IRA, a 401k, a life insurance policy, an annuity is going to have a beneficiary on. And then quickly, you're going to have, with a beneficiary, you're going to name it either per stirpes or per capita. And that's kind of a weird word, but it's I think it's Greek or Latin or something. But what per capita means is that the living beneficiaries are going to split up the money by the heads per capita. So if one of your children dies before you, and you've got 3 children, and one of them dies before you, it's going to the money's going to pass half to the living child, half to the other living child, nothing to the other child, to the heirs of the other child. If it's per stirps or stirpes, it's going to be 1/3 to the child named that's alive, another third to the child that's alive, and then they're going to take the third of the deceased child and divide it up. So I don't want to get that technical about it, but it usually defaults to per stirpes. And if you come to us, we can help you in naming all your beneficiaries. But the point of all this is, if you have named beneficiaries, the money is going to go directly to whoever you name and avoid the probate court. Now I want to put it to Tom to talk about transfer on death and pay on death.
Yeah, so these transfer on death and payable on death designations on accounts are highly underutilized. There's a lot of people that have done this stuff with the IRAs and the 401ks, probably because it forced you to do it when you were filling out the account application. But things like bank accounts, brokerage accounts, money that's not in IRAs or Roth accounts would be under that IRA tab. They don't prompt you a lot of times. Banks don't often, if you're opening up a checking account, savings account, banks do not normally prompt you if you want to put someone on there. And fundamentally, they work just like a beneficiary, right? As it passes upon your death, it passes to the next, whoever's named there directly. It doesn't have to go through the will. It doesn't have to go through probate. It goes right to them, just like a beneficiary would on your IRAs and life insurance and other types of accounts. And so I would highly recommend people go ahead and do this, because at the end of the day, the whole goal here, the whole point of this video is to have things pass to who you want them to go to in the easiest way possible. I mean, that's really why you do a lot of this planning, is not bringing in the courts, not going all the stuff that Hans just talked about, is it goes directly to who you name. Now, with that, and we'll get to this a little bit later, you need to be a little bit careful, right? Because when you die, if you have a beneficiary, if you have a payable on death or transfer on death, it's going to happen prior to the will being executed. So if those are not in line with each other, you might have things go to who you don't want to go to. We'll go through some examples a little bit later. But at the end of the day, these transfer on death, payable on death, you can add them to checking accounts, you can add them to savings accounts, you can add them to taxable brokerage investment accounts. And again, they work just like a beneficiary, goes directly to the named person upon your death. You're not giving up control. This is different than adding a joint owner to the account. Like, so some people say, well, I don't want to give control to my child or whoever, my son or my daughter, because I want to control it now, which is totally fine, right? You're not giving up control. It's still your account. It's just what happens to that account upon your death. You've laid it out with the institution. And I would highly recommend that everyone do this on the accounts that don't have these already titled on there. So, Hans, why don't you talk a little bit about what do you do with real estate? Because we just, like, all financial accounts really can be either beneficiary or transfer on death. So if you have money in an account, you can title it that way. Real estate or tangible property, that sometimes can get a little bit more tricky to have that pass outside of probate. So, Hans, why don't you talk about what are some options there?
Okay, I want to add one point on this, or a couple points. These are underutilized. I mean, generally, when you open your bank account, the person on the other side of the table, I guess you don't sit down with somebody anymore, it's virtual, but the banker filling out the application or typing it in, they don't use it. Who would you like to name as the transfer on death on your account? I mean, it's just, I've never heard of that happening. So when we see accounts of people coming into us for financial planning, they generally don't have any transfer on death and pay on death. Now, this is different than a joint account. We see a lot of people coming into us where their daughter or son is named on the account as a joint owner, and they think they're accomplishing the same thing, where it's going to pass to their son, assuming their son dies after they do, or daughter, but they're giving control of the account during life. I mean, your son could go empty that account. I mean, there could be a lot of things. He could have legal challenges. So that's a whole nother area. This is underutilized. So it's one of the benefits of coming into us for financial planning is we're either setting up new accounts that are going to accomplish different things for you, and then we're going to get the name beneficiaries and transfer on death and pay on death done properly. But it also, if you come into us and we do financial planning, even if we don't transfer the accounts, we're going to go through these. And I can think of a person that we're dealing with right now where we have a fellow who's in his last years, maybe in his last months, and his marriage is a second marriage. His first wife passed away like 25 years ago, 30 years ago, and a lot of the property is still in his name. And so, he has a will that leaves it to his wife and then his daughter from the previous marriage. But there's some problems there. I mean, first of all, it's going to go in the probate court. The property is going to be tied up forever. And so one solution was just put his wife's name on the deed. Now we're down in real estate. But then if we did that, we would lose the step up in basis. Some of this property is substantially appreciated. So I don't want to get too much into an example. Most people that come to us and we go through everything, a lot of this stuff is not in order. That's the point I'm trying to make. And when it's put in order and it covers all the accounts, I'm not talking about most of the accounts, but all the accounts, we have a properly named beneficiary or we have a properly named transfer on death, we can rest assured that their money is not going to end up in the probate court. So now, as Tom said it, we're going to talk about real estate, because you can't put a beneficiary on real estate or tangible assets. Unless you live in one of these 30 states, they have what's commonly called a beneficiary deed. Sometimes these are called ladybird deeds. You can Google your state and you can find out if these are available. And if we're doing financial planning for you, we can help find an attorney that's familiar with the beneficiary deed in that state. And when we redo all your documents, we can actually do this. So if the only asset you have is a home, and you plan to hold that until your death, you can actually name a beneficiary on the beneficiary deed. So, and it's different in every state. Now, if you're not in one of those states or you want something more comprehensive, you can use a revocable living trust. And what I'll just say as a word of caution is I'm only talking about putting in the trust the real estate, okay? Now, there could be reasons for you to put financial accounts into the trust, like you want to have somebody else control the money after you die because you don't trust your kids handling money, if your adult kids or whatever. There could be all kinds of reasons to put money and have the beneficiary be the trust and to put the money into the trust to have it managed. But I'm not talking about that. I'm just talking about where we've taken all the financial assets and we've taken care, they're going to bypass probate, but what we got left is tangible assets and real estate. The simple thing to do is put them in a revocable living trust, and then they will just transfer. They're already in the trust. So when the person dies, the trustee of the trust dies, and the grantor, the beneficiaries of the trust or the new trustee will just distribute them outside of the court to whoever the named beneficiary within the trust is. So there's ways to do this, and then I want to talk with Tom just about some of the do's and don'ts. So Tom, why don't you take the first one of these?
Yeah, so the right side of the board, we have some sort of key points, and the first one is don't name the estate. And Hans talked about this a little bit on the earlier part of the show. But if you, on a lot of these, and specifically on the beneficiaries, IRAs, 401ks, life insurance, those type of things, you could list your estate as the beneficiary, which satisfies their requirement to name something down. So I guess it's better than nothing. But really, what you're doing is essentially you're naming the will as the beneficiary. It brings it into the estate. You are guaranteeing it's going to go through the probate process if you name your estate as the beneficiary. And then, especially with things like IRAs and 401ks, money that hasn't been taxed yet, that really prevents you from using some of the provisions that are in the law now to stretch those distributions out over a longer period of time. And so, you sort of have the worst type of designation, meaning they have 5 years. The beneficiaries of the estate have 5 years they have to distribute it. I don't want to get too far into the weeds there, but it limits their options. It brings in the probate process by definition, and the whole goal of this is to try to avoid that. So you really want to name individual people, and if you don't have somebody to name, start thinking about charities or who you want to get this. You might have nieces, nephews, siblings. Everyone's situation is different, but you really need to think through a person or a named organization like a charity to receive this money, and don't leave it as your estate there.
Yeah, I mean, we just have one of these last week, an IRA, and the IRA named the estate, and our client is the beneficiary, the executor. This was his sister. And now, not only does he have to distribute it over 5 years, instead of being able to stretch it out over his lifetime, he has to pay taxes at trust tax rates, which are much higher. So naming the estate, not good, unless there's a real reason to do it. Paid to the beneficiary before the will is probated. So that's the whole beauty of this thing is that, a beneficiary is going to receive their money in 30, 60 days, maybe even a little shorter than 30 days. People get their money out of probate many times years later. So this is it trumps the will. The beneficiary designation sits first and happens first long before the will is read. When they're reading the will and they're doing the will in probate, the money's already over there and many times spent, or some of it spent. Tom?
Yeah, I mean, on that point, I'm gonna make another point, then we'll go to the next one. When it's paid to the beneficiary prior to the will, I can't tell you how many of the times when we start going through our 7 worries and we're having an initial conversation with somebody and we get to the estate planning, right out of their mouth comes, "Oh, I already have a will. I've already set that up." Which is great, right? I mean, that's one of the things we check. Do you have a will and everything? So we want you to have a will, but we need to spend a little bit of time to make sure that the beneficiary designations match what's in the will. I mean, I'm thinking of a client that it's been a couple of years now. She came in and had her ex-spouse listed as the beneficiary on this account. News alert is if you die and you have an ex-spouse on that as a beneficiary, they are the ones who receive the money. Even if you're married, even if your will says something else, even if you haven't talked to them in 10 years, doesn't matter. If it's named as the beneficiary, they are going to get the money. And it is really, really hard. The courts have upheld this time and time again. It is really hard for the surviving spouse, if they're married, to go back and try to claim it against someone who's named as a beneficiary. So you really need to make sure that your beneficiary designations match the will. And the whole goal is to have things passed to the person prior to getting the will, but you need to make sure those are in line with each other. The next one is update the beneficiaries or the transfer on death when there's any changes. So like think of marriage or divorce or birth or death. I guess it's not you dying because that's when all this is being executed. But if you have a beneficiary who passes away, so I'll give you a really good example. Say we have a married couple, a husband and wife, and they have 2 kids. And the husband has named his wife as a primary beneficiary and vice versa. She's named him. And the kids are contingent beneficiaries. Well, when the first spouse passes away, we'll say the wife passes away. What the husband should do is rename the beneficiaries as the kids being the primary beneficiaries. I guess it's not entirely necessary. If he never does it, it's still going to pass what he wants to, but it causes more hassle to the kids on the back end, because what they're going to have to do if they were not named as the primary beneficiaries when he dies, they're going to have to go back to the institution, the financial institution, prove that their mother passed away first. So then they got to provide the dad's death certificate, the mom's death certificate. They got to look at the dates of both of those, then confirm they're the contingent beneficiaries. It just adds more steps to the process. So when someone dies, one of your beneficiary dies, say they get married, say there's a divorce happening. I mean, there's a lot of things that can happen. But when life changes, you need to go back, revisit the beneficiary designations, make sure they're still listed like you want them to be.
Okay. And then these insurance companies, mostly, and the IRA, the 401k custodians, they want the name, the address, the email address, the cell phone number. They want as much information as they can on these beneficiaries now when you're opening the account, so that when this happens years later, they can find these people. And often they have to, maybe they can find one of the three beneficiaries, and they're going to have to interview that one to help them find the other two. So not only do you want to get this stuff listed when you open a new account, you want to go back into your old accounts and update it all and get all your kids' information in there so that this passes real smoothly. If we're talking about contingent beneficiaries. So all that being said, this is really important, and this is a kind of a hidden advantage of dealing with us and doing a financial plan through us and with us, because we take this real seriously, and we go through everybody coming in, and we're going to go through, get a list of all their money, how it's invested, where it's going, what the tax situation, and then who's the beneficiary on the account. And we want to know that. Who are the contingent beneficiaries? And then we want to get the order of all that. And if they're not the way they should be, we're going to assist you in filing change of beneficiaries. So that's just a very important step in the process. And about the only subject that we've covered today is estate planning. It's a piece of our overall financial planning. Maybe we talked a little bit about taxes, and we talked a little bit about 401k IRA, because any qualified account, IRA, 401k, is going to have a beneficiary, and make sure you keep that up to date, and it's not the estate. And so I'd like to bring Tom back on. I'm Hans Scheil.
And I'm Tom Griffith.
And we thank you very much for listening.
Thank you.